Alright, so welcome to the second part of the video lecture on Chapter 6. This part is dealing with slides 48 through 61 if you're following along, and this deals more with the witness's duties. So a witness cannot refuse to answer a question because they anticipate the next question could incriminate them. They have to answer every question that does not incriminate them. And the fact that a question might incriminate somebody else, a friend, a spouse, somebody, is also not a reason to refuse to answer a question. So witnesses have to answer, again, the gist of this is that witnesses have to answer questions, even if it's embarrassing or degrading. Unless that question is going to directly incriminate them, they need to answer all questions. Now, a witness can waive their privilege against self-incrimination. They can testify about an incriminating event if they so choose. This cannot be forced. This is solely the privilege, the right of the witness alone, whether or not to invoke or waive their privilege against self-incrimination. The lawyer cannot claim it for them. It's solely within the purview of that witness. If the witness waives privilege, the privilege is waived for the entire matter. So you cannot choose to testify about the good parts of the incriminating event and leave out the bad parts. Once you waive your privilege, it is gone. Now, sometimes, especially in criminal cases, witnesses are engaged in criminal deviant delinquent acts just as much as the defendant. So prosecutors can allow witnesses to be spared from being prosecuted if they furnish facts that would incriminate them. This is called immunity. There are two types of immunity. There is use and derivative immunity and transactional immunity. Now, use and derivative immunity prohibits the use of any testimony that is specifically immunized and any evidence derived from it. So kind of like following the chain for that immunized witness. Now, transactional immunity protects the immunized person from prosecution for all activity mentioned in their immunized testimony. So transactional immunity is sometimes called blanket immunity, and it is the better type of immunity because it gives the witness the most protection. So if under use or derivative immunity, you get immunity for the events of a drug deal that you bought drugs from, and then it comes out that you had a gun there that the prosecutor didn't know about, you can be prosecuted for possession of that gun that you should not have had because you were only protected for evidence pertaining to that drug deal, and that's it. While if that witness had obtained blanket immunity, they'd be protected from all actions related to. Since 1972, prosecutors can give witnesses immunity as long as the evidence has been obtained from other sources as well. This just kind of allows protections for to make sure that the evidence is actually consistent. Now, the defendant has a privilege against self-incrimination as well. So the past few slides have dealt with witnesses who are not the criminal defendant themselves. The criminal defendant has privilege against self-incrimination, pleading the fifth. Defendant cannot be compelled to take the witness stand under any circumstances. Now, a defendant can choose to take the stand. That is in their own defense, that is their choice, but they can also choose to remain completely silent. And if they do so, the prosecutor cannot comment on that. The privilege against self-incrimination applies because we cannot engage in testimonial compulsion. Now, self-incrimination is testimonial compulsion, requiring someone to take the stand and answer questions to provide their testimony. something that is generally, things that are generally not included in your privilege against self-incrimination include requiring a defendant to perform a certain physical act or give physical evidence like blood or things like that, speaking, so that the witness who maybe only heard something can say whether or not that was the voice they heard. All right. So these things have been litigated out in the federal courts largely here, providing blood, providing fingerprints, hair samples, speaking for voice identification, exhibiting oneself before the jury. Those things are not, you do not have privilege to avoid those things. Now, for DNA, that has been heavily litigated, and in 2012, the Maryland Court of Appeals held that taking DNA was a violation of search and seizure, and the Supreme Court overturned that decision, holding that taking a cheek swab of an arrestee's DNA is a legitimate police booking procedure that is reasonable. Now, they cannot pick and, you should not pick and choose this. You should engage with it with all witnesses. Now, if you have any questions or concerns, definitely reach out.